Justice Jackson?
Yes. As you might imagine, I would like to circle back to the concerns that the Chief Justice and Justice Kavanaugh raised about vacatur and the argument that you're making in this case. And
seems to be a kind of D.C. Circuit cartel.
It is. And in particular, the conceptual problem that I'm having with your argument. You point to text, context, and history, and I understand those things. But ordinarily, there's a symmetry between the claim that is being made in a case and the remedy that is provided to a successful plaintiff. And your remedy, the way that you're reading this, actually creates a disconnect for me. Here's what I mean. It is clear that the claim under the APA is about the manner in which the agency has exercised its discretion. And we know that agencies have no inherent authority. They get all of their power to make valid and legally binding policies from Congress. And Congress has said in the APA that in order to make valid and legally binding policies, agencies have to follow certain procedures. So when a plaintiff is making a claim under the APA, they're complaining about the agency's failure to follow the procedures that are necessary in order to reach a valid and legally binding result. Given that that's the case, I think there's a disconnect to say that the successful plaintiff only gets a remedy that is about the application of that rule to them, because their complaint is not about the application. Their complaint is that the agency did not have the authority to do what it did because it didn't follow the procedures under the APA. It's as though they're saying what the agency did is void, it's a null set, because they did not follow the procedures that Congress required. So I just don't even understand. Setting aside how you read the statute to get to that result, it seems to me to not make sense to say that the remedy is to allow the agency to apply its void, defective rule to anyone else who's not the plaintiff.
So, Justice Jackson, I think where I disagree with your analysis is in suggesting that a plaintiff in a case isn't protesting the application of the invalid agency regulation to that party. That's the very nature of this kind of dispute. Now, it might be the case that the arguments they're making
but
about
I'm sorry, it's not the nature, because, I mean, obviously they are saying it was applied to them as a matter of standing. You have to have it applied to you in order to make the charge. But the claim is that the agency has failed to have notice and comment where it was required, or the agency has engaged in arbitrary and capricious decision making. And if that's true, what it means is that the agency does not have a valid exercise of its discretion per Congress's requirements. The result then is that the agency doesn't have a rule that it can apply. And the statute says very plainly the most common sense result of that is just like in a contracts case. If the court were to find in a contracts case that the contract is void because it wasn't properly formed, the result is not you can apply it to whomever, just not the plaintiff standing there. It's not a thing anymore. And that's, to me, what the statute says. You set it aside because you haven't formed it properly and consistently with what Congress has said.
I certainly acknowledge that when a plaintiff is challenging the agency's decision-making, their legal theory could suggest that the agency regulation is invalid in all of its applications and as applied to other parties too. But I still think that in that case, just like in the case of interpreting a statute, the proper remedy is the party-specific relief.
But we don't have it. The APA is a different kind of claim. It's not the statutory claim is not about Congress's authority to make the policy decision. Did they follow the right procedures in making it? Let me ask you about 1252 F, because that's another basis that you sort of suggest that courts' authority is limited. When I look at 1252 F, it says that there's no jurisdiction or authority to enjoin or restrain the operations of the provisions of this subchapter, which seems to me as though Congress is prohibiting an injunction of the statute. You've interpreted it, I think, to mean operation in the sense of any regulations, any policies of the government that are implementing that statute. But I guess I'm concerned about that because in E3, just the provision prior, Congress was very clear about spelling out things like regulations, guidelines, et cetera. I know that's a different provision because it applies to expedited removal, but Congress knows how to say when it's talking about claims being brought about guidelines, procedures, and things that the agency does. And yet in this statute, in F, which would, I think, also apply to E, it talks about the operations of the statute. So why isn't really what's going on here that Congress didn't want its new regulations, its new policies concerning immigration to themselves be enjoined, and it wasn't really talking about the agency's implementation in this provision?
So I think that that approach would be inconsistent with the court's decision last term in Aleman-Gonzalez, where the claims of the non-citizens in that case is that they were entitled to bond hearings under these provisions, and the court recognized that this bar prevents an injunction that would prevent the executive from implementing its policies with respect to bond under that statutory language. And so I think that the same argument potentially could have been made there, that that's not actually enjoining the statute, it's enjoining the agency's policies that are consistent with, in the agency's views, those statutory provisions.
All right, so what do we do about F as it applies to E? And again, I know E is not in this case, but if we're going to be interpreting F, is it your view that the limitation on injunctive relief, as you have interpreted it in F, applies to challenges on the validity of the system in E in the expedited removal context?
Yes, I think that we would take that position because as we understand this court's interpretation in Aleman-Gonzalez, it focuses on whether the claims in the case are premised on these statutory provisions and are seeking to require DHS to implement the covered INA provisions in a particular way. And so if the theory of the case were under 1226, any of its provisions, DHS is required to interpret the statute in a particular way or to take particular action. That comes within the bar that 1252 announces.
Then we have a statute here at E in which Congress has authorized very specifically a claim. Congress has said that you can bring a case in order to challenge a regulation, policy directive, written policy guideline, or written procedure of the Attorney General or here DHS. Congress has allowed that, and you're suggesting that the only relief is declaratory relief under those circumstances, that you don't even have to follow, really?
So there is the opportunity for declaratory relief in any court. 1252F1 also permits coercive relief on behalf of individual non-citizens, and 1252F1 preserves this court's authority to enter any form of relief. So I think that those are the remedies that Congress delineated under these statutory provisions.
Thank you.
Thank you, counsel.